Hi, my name is John Syrtash. I'm with the firm of Garfin Zeidenberg in Toronto, and I'm a Toronto area family law lawyer that deals with divorce, child abduction, all sorts of things. And I've been around in this business for 39 years. What I'm doing today is to try to give you some ideas as to the parenting crisis that is being worsened now. During my last email, which you can also click on, deals with the general issues that are going on right now because of COVID-19 and some very simple steps on how to solve these issues without worrying about lawyers and divorce and separation and all that. So this video is for those people that have tried those methods or don't want to be bothered and now want to know what to do legally and are truly interested in separation and if you're married, divorce. First, you have to know something very important. July 1st is an important date, at least in Canada it is, because in Canada, if you're married, the law is changing entirely about parenting. All the normal terms that we're used to, like custody and access, will disappear, and there'll be a whole new approach on how parenting disputes are resolved in the courts of Ontario. So that's the first thing I need to mention, and I'll get to that. The second thing you need to know is that if you're separating now, and you want to separate now, and you figured out how you're going to leave the house or how you're going to stay in separate bedrooms or something like that, you need to realize that as far as parenting disputes are concerned, unless it's very urgent and has to be resolved immediately, the courts in Ontario and in most provinces of Canada are not open. Most of them are not open physically for anything, except for some very few hours. So what I mean by the courts aren't open, they aren't open for normal disputes. They're open for urgent disputes only. And what do urgent disputes mean? Well, say your spouse or your common law spouse has not returned to your home with the child and you have a custody order, or there has been a understanding as to what the parenting arrangements would be, and the child was supposed to return by a certain time and he or she is not returning, then you may have an urgent issue. Depends on all the facts, but that's one aspect. Another issue is, well, of course, where there's violence in the home and you have to see a judge right away because the police may not be listening to you, or maybe you're the victim of a false allegation and you've been kicked out of the house and you want to see your kids. So for many reasons, the courts are still open, but they're open under very strict rules on how to go into court. And I'll get into that. And also, those applications have to be of an urgent nature until this thing is over. This whole COVID-19 crisis is over. So the term custody and the terms access are going to mean very little. Actually will mean nothing as of July the 1st. But if you're going to make an application now on one of these urgent situations, then you have to realize that you'll be dealing with applications for relief which just impact very much on COVID-19 and the way it's dealt with. The way the courts in Ontario have been dealing with it is a general rule that if you have an existing court order of custody or access or some kind of shared parenting arrangement or parallel parenting arrangement, I'll describe what those terms, child or refuse access to a child in breach of a court order just because of COVID-19. This may be the singular most important thing I have to say on this video, because most people think that somehow COVID-19 may give them an excuse to withhold a child or prevent access to a child or retain a child when the other parent has custody. That's not the case. If you have a court order or you have a written agreement that says that the child should be with you by a certain time on a certain day, and there's a schedule, and that's a court order or a written agreement, then you should have the right to go to a lawyer. The lawyer can make what's called an urgent application to have the child returned, because COVID-19 on its own is not an excuse. Unless, and there's an exception to this, you've got clear proof, which is maybe difficult to get, that your partner or your former partner or your former spouse is refusing to follow the laws or the rules depending where you live, on social distancing. If you have been social distancing yourself and you've been keeping everybody clean at home, and you do everything that we're supposed to be doing now, and you've got some very strong proof that your partner or spouse is not doing that or doesn't care less about any of these rules, then you may have a case for having the child back in your care, or if the child's already in your care, not allowing COVID-19 not allowing COVID-19 to prejudice or jeopardize your child's safety. But if that's not the case, and you're only using COVID-19 as your, based on your fears that this could happen, well, the law right now, as it's settled in Ontario recently, in the past 2 weeks, actually, it's been pretty fast, is that a parent is deemed to be safe with their child during this crisis if they have a court order. Now, if they don't have a court order, it becomes more complicated because the courts are sort of divided on this topic. If you've already commenced a court application, then you may possibly be able to get access to a child, notwithstanding COVID-19, or you may get custody of them, but not prevent the other parent from having access to them, depending on the circumstances, which are unrelated to COVID-19. But if you haven't even commenced an action of any kind, then you're going to have a problem, because the courts, the way I read it right now in Ontario, are not listening to people at all if they haven't commenced an action. And that is, there may be some, if you want to be creative, there will be some lawyers that will take on that job, but the courts have not I haven't seen any cases yet where the courts have said yes, even in the absence of a court action where you've just commenced it or plan to commence it or something like that, you're going to succeed on the basis that your spouse or your partner is refusing to allow you access to your child, or you're retaining a child in the face of an existing arrangement because you haven't started a court action. So if you're going to do something like this, you have to know the first thing to do is to see a lawyer, even if it's over the net, like we're doing now, and retain them to commence a court action for custody or access. And after you've done that, then you bring your motion, what's called the motion, then you ask to see a judge just to do something about it. And that can be done in there are different steps you have to take to do it, but at least you're in court and you'll get the job done. A lawyer will tell you what to do. I'm not going to bore you with all the details, but that's a very major piece of news you all need to hear. Now, in terms of what it is that custody and access is really all about, custody really means that you have the sole decision-making power over major decisions such as education, health, religion, and general welfare of a child, and that the other parent, if you have sole custody, has the right to see the child at prescribed times or as you've arranged between the two of you. If you have something called shared custody, and these decisions, and these major decisions have to be shared equally through discussion or through mediation, depending on the circumstances. And it means that you have to share decisions over health, education, religion, or general welfare. You just can't do it on your own without the consent of the other spouse. If you don't have an agreement of any kind, then you're deemed to both have the same powers of decision making, which is another reason you may have to go to court. There's something else now called parallel parenting. And parallel parenting means that some of you, or one parent, may have decisions over a certain kind of decision, and the other parent has decision-making authority over the other kind of decision. For instance, the wife may have sole decision-making power over which doctor the child, or which doctors or medical care the child will receive. The other parent has the same sole decision-making power over religion or over education, which school the child goes to. So that's another kind of parenting. Whatever it is, during COVID-19, if you have a court order or a written agreement that says these things, then you're permitted to go to court, and if a child's not been retained. Now, if you're one of those people. Anyway, I've given all of you a great deal to think about. I'm happy to answer any questions free of charge to anybody who calls me. I'll be giving out legal information, not personal advice, but I'm happy to do that. And if anyone wants to retain me after that time, then I'm happy to do so as well. Even during COVID-19, I'm readily available on camera or over the phone, and retainer arrangements can be made. But as I said, you get a free consult the first time you call me. Hopefully that was all interesting, and I'm happy to answer any questions. Keep safe, stay indoors if possible, and hopefully everything will go well for you and your family. Thank you.